As Professor Galic mentioned today in the first segment of my presentation, I will be walking you through the Brussels 1A regulation and the remedies concerning the enforcement of judgments between member states. In particular, we will be discussing the concept of remedies, that is to say, which are the remedies that the judgment debtor can rely on once a request and application for enforcement is brought by the judgment creditor in another member state. The second aspect will be which grounds of refusal for recognition and enforcement exist, especially in light of the abolition of exequatur that has been brought forth with the recast of the Brussels I regulation. And I should like to point out that both these aspects actually contain novel aspects as compared to the Brussels I regulation. And we will see how. And also the third topic is a novelty to some extent, and it relates to the adaptation of judgments. What is a court, and we will see also the problem of which court is supposed to be seized for this, but what is a court of a member state address that doesn't know the measure or order that has been issued by the court of origin do when it is asked to recognize but especially enforce that unknown under its own law measure and or order. Before getting into the details of these three topics, I would like to briefly devote a little time to the legal basis of all these provisions and overall of the Brussels 1A regulation, because this embodies and enshrines the legal basis in partly for mutual trust as concerns judicial cooperation in civil and commercial matters. This has contributed, and this provision, which is Article 81 of the Treaty on the Functioning of the European Union, which mirrors largely the previous Article 65 of the Treaty establishing the European Community, is the legal basis for judicial cooperation in civil and commercial matters, and has remarkably contributed to establishing an area of freedom, security, and justice. And when we talk about an area of freedom, security, and justice, we talk about the area of EU law that is meant to foster and ensure freedom of movement within member states. And when we talk about freedom of movement, indeed, we talk about freedom of movement of persons, capitals, goods, services, but indeed, we also talk about freedom of movement of judicial and extrajudicial decisions. So this provision is the legal basis for what we're talking about, and this is what made it possible in the first place. What this provision states is that the Union shall develop judicial cooperation in civil matters, having cross-border implications, based on the principle of mutual recognition of judgments and of decisions in extrajudicial cases. And for the purposes of achieving such judicial cooperation in civil matters, the European Parliament and the Council shall adopt measures aimed at ensuring, in particular for our purposes, mutual recognition and enforcement between member states of judgments and of decisions in extrajudicial cases. Now, this is a strong statement. This is a much stronger statement than the one made at Article 220 of the Treaty establishing the European Economic Community, which was the legal basis for the 1968 Brussels Convention, which actually enjoined member states to negotiate towards more simply simplifying the formalities for recognition and enforcement of judgments. Again, a foreword. Article 81 of the Treaty on the Functioning of the European Union is the legal basis not only, of course, of the Brussels 1A regulation. It has actually allowed the adoption, it has formed the legal basis for the adoption of several other very remarkable for some reasons, for many reasons, regulations that fall exactly in the same scope of application, in the same area in which the Brussels 1A regulation operates. These are, in particular, the regulation creating a European enforcement order for uncontested claims, the regulation regulation creating a European order for payment procedure, the regulation establishing a European small claim procedure, and in addition, the regulation establishing a European account preservation order. I am naming these regulations for two reasons. On the one hand, initially, they were meant to significantly contribute to the establishment of mutual trust, and especially to the establishment of a smooth mutual recognition and enforcement of judgments between member states, because one of their more remarkable features was that within these regulations, and I'm talking about the first three that you find listed in the PowerPoint, was the abolishment of exequatur. So that was, among others, the striking feature that was brought forth by these regulations. Of course, as you may well understand, to some extent, now this feature is less significant as a result of the recast of the Brussels I regulation, because we will see it later, but you already know that as a result of the recast, the exequatur has been abolished also in accordance with the Brussels I-A regulation. I shall point out, however, that the conditions are not necessarily the same. Now, I don't want to devote too much time to these regulations, so there are still differences, but the most remarkable difference has actually been lost or actually has been absorbed by the Brussels I-A regulation. I should also point out that quite interestingly, well, these regulations right now form the object of a study that is being conducted by, among the others, the Max Planck Institute Luxembourg, the University of Antwerp, the University of Freiburg, and the University of Milan. And actually the final conference is taking place right today. And from this study, it appears, however, that even before the Brussels I regulation was recast, and therefore even before the abolishment of exequatur in the area of the civil and commercial matters, these regulations do not appear to have been very successful. Now, it would also appear from this study that one of the reasons was that these regulations are actually not very well known by practitioners and by the judiciary. So I do hope actually that this study will foster and further more knowledge of these regulations, and this is why I thought it was important to also at least bring them to your attention for any future purposes. Recognition and enforcement is enshrined in Chapter 3 of the Brussels I-A regulation. However, before we look into the hardcore rules, I think it is also of significance to look into especially one recital. Of course, you know that recitals are not authoritative, so they're not prescriptive, they're not hardcore rules, but I find, and of course they are, it's not a personal opinion, they do provide very significant and helpful information. Background information that allows the interpreter to better understand the meaning, the scope, the interpretation of the hardcore rules. As concerns Recital 26, it is of particular interest because it, of course, recalls mutual trust, but it also establishes, again, not authoritatively, but it establishes, it raises at the level of background information, of principle, actually, the equal treatment of judgments. And the recital states that mutual trust in the administration of justice in the Union justifies the principle that judgments given in a member state should be recognized in all member states without the need for any special procedure. In addition, the aim of making cross-border litigation less time-consuming and costly justifies the abolition of the declaration of exequatur. So it gives you a little bit the idea, the foundation or the rationale of mutual recognition and enforcement, indeed. But finally, and more interestingly, it also states that in addition to making cross-border, and of course, as a result, this entails that the moment you are a judgment creditor, you don't have to go through any particular specific procedure for the declaration of enforceability. What is, however, of importance, and this is something that we were briefly discussing now with Professor Galic, and I'm sure that you deal with this on a daily basis, is that we will see that when we talk about enforcement, there is an interaction between the procedural law of the member state of origin and the member state addressed. However, what the courts addressed find very often not so clear is who is competent for what within the domestic system that is being addressed for the purposes of recognition and enforcement. So while the two systems, of course, cooperate in several ways, in possibly successful ways, and while, of course, the abolition of exequatur is welcomed, it was initially actually supported by the European Commission as far as in 1999 with the Council of Tampere, and it was finally brought to fruition with the Brussels 1A regulation. It is to be welcomed, but it doesn't solve all problems. Actually, to some extent, it raises new problems. Moving on to the hardcore rules. Articles from 36 to 38 regulate recognition, and notably Article 36 paragraph 1 mandates that recognition be automatic by stating that a judgment given in a member state shall be recognized in the other member states without any special procedure being required. This is not a novelty. This is something that was already in place under the Brussels 1 regulation. As we mentioned, the novelty comes with the abolition of exequatur, which is stated in Article 39 of the Brussels 1A regulation, which mandates that a judgment given in a member state which is enforceable in that member state shall be enforceable in the other member states without any declaration of enforceability being required. And of course, as a result, you simply, as a judgment creditor, you simply, again, quotation marks, will file a request for the enforcement in the member state addressed, with all the caveats that we just mentioned. Finally, what happens if you, as the judgment debtor in this case, want to try to bring an opposition to the enforcement? This is governed by articles from 45 to 51, and we will see how they work and how these provisions interact. As I mentioned earlier, the first topic that we look into is the concept of remedies. Now, remedies come into play when you, as a judgment debtor, have received notification of the fact, have received knowledge of the fact that enforcement of a judgment rendered against you in a member state is being sought in another member state. Indeed, reasonably, within reason, and if this is supported by facts and law, the one thing that you will try to do is try to object to the enforcement of such judgment. But what are the instruments that the regulation provides you in the interim time? What are the remedies that you can rely on while the enforcement proceeding is progressing? These are regulated at Article 44 of the Brussels 1 regulation, which states that in the event of an application for refusal of enforcement of a judgment pursuant to subsection 2 of section 3, the court in the member state addressed may, on the application of the person against whom enforcement is sought, limit the enforcement proceedings to protective measures, make enforcement conditional on the provision of such security as it shall determine, or suspend, either wholly or in part, the enforcement proceedings. It should be noted that in accordance with the Brussels 1 regulation, the debtor was not devoid of remedies. However, the Brussels 1 regulation, as well as the 1968 Brussels Convention, only provided for one option, and that was the suspension of enforceability. It was deemed appropriate to actually provide a little bit of more flexibility, but at the same time also being more on point with respect to the available remedies. One thing that should be actually emphasized is that remedies may be granted only upon parties' application. So the court of the member state addressed may not, on its own motion, at least according, of course, to this provision, may not grant a remedy. However, once the court is seized with the request for a remedy, it may grant one of these remedies. Of course, here discretion is inevitable, I would say, meaning that the court will look into the instant case and verify whether there are reasons that support granting one of these remedies. The remedies laid out at subparagraphs A and C actually have an impact. They actually affect the enforcement procedure, because either they limit the enforcement to protective measures, or they entail that the whole or part of the enforcement proceeding be suspended. So you do understand, of course, that this has a clear and, if you will, practical, objective impact on the enforcement proceedings. Whereas the one at subparagraph B pursues a different, actually, objective, and that is to say that it simply makes enforcement conditional upon a security. This means that once the security is deposited by the judgment creditor, the enforcement proceedings will resume. It is possible that the court of the member state addressed suspend the proceeding until security is paid. This is more than reasonable. But once it is paid or deposited, the proceedings shall resume. Paragraph 2 of Article 44 also states, and this is an important aspect in equal treatment of judgments, that the competent authority in the member state addressed shall, on application of the person against whom enforcement is sought, suspend the enforcement proceedings where the enforceability of the judgment is suspended in the member state of origin. Now, this is again upon parties' request, so the court may not grant it on its own motion. But unlike what we saw in the previous paragraph, if the court is asked to suspend, in this case, it shall. So this is mandatory on the court to suspend the proceedings. Again, an open question, and this is left to the national procedural law of the member state addressed, is which is the competent authority in the member state address to take this decision, and so which is the competent authority to which the interested party shall refer to plead his or her request. Coming to the core of our discussion, what are the grounds for refusal of recognition and enforcement? Well, we've already seen abolition of exequatur under Article 39. The grounds for refusal of enforcement are actually laid out at Article 46 of the Brussels I regulation, which state that on application of the person against whom enforcement is sought, the enforcement of a judgment shall be refused where one of the grounds referred to in Article 45 is found to exist, which means that now once we if you, as the judgment debtor, want to object to the enforcement of a judgment rendered in another member state, you will, of course, rely on the same grounds that have been laid out under the Brussels I regulation for recognition. This is actually more than sensible for a number of reasons, and especially for consistency within the instrument. So Article 45, which is referred back to by Article 46, provides the core of the reasons and the grounds for refusal of both recognition and enforcement. Now, you will see immediately that, again, this operates, and again, this is sensible, only upon parties' request. But once, as we have seen in the second paragraph of Article 44, once the court is seized with a request for refusal, the court, if it finds that one of these grounds apply, the court shall refuse recognition and enforcement. So, on the one hand, this provision is obligatory or mandatory. If the court finds that one of these grounds applies, the court shall refuse recognition and enforcement. On the other hand, these are also exhaustive grounds, meaning that the court may only ground a refusal for recognition and enforcement on one of these grounds. This is true, and this is absolutely true, well, for a number of reasons. Of course, we've been talking about mutual trust. We've been talking about the importance of mutual recognition and enforcement of judgments, of freedom of circulation of judgments. What this provision does is to provide for some, if you will, residual and yet very compelling safeguards that protect the interests of the parties in some cases and of the member state addressed in some other cases. I have said that these grounds are exhaustive, and they definitely are. They are exhaustive when we're dealing with the private international law dimension of the enforcement procedure. This, however, is not wholly true when we go beyond that aspect and we look just into the national dimension of enforcement. This is found in particular in Article 41 of the regulation, which takes us back to the relevance of national grounds for refusal of recognition and enforcement of the member state addressed. And what this provision does, it states that the procedure for the enforcement of judgments given in a member state shall be governed by the law of the member state addressed. As I mentioned, there is a sort of interaction is not the right word, but if you will, the procedural law of the member state of origin and that of the member state address are complementary. Think, for instance, at the certificate that is provided for at Article 53 of the Brussels 1A regulation and laid out in Annex 1 of the regulation, which is within the control of the court of origin. And it actually is a reflection of the law, of the procedural law of the member state of origin, as is enforceability to some extent of the judgment for which recognition and enforcement is being sought. On the other hand, however, and again, this is quite understandable, the procedure for enforcement is actually governed by the law of the member state addressed. The provision continues by stating that a judgment given in a member state which is enforceable in the member state addressed shall be enforced there under the same conditions as a judgment given in the member state addressed. This is again necessary because if this were not the case, we would not really have the same judgment circulating in the area of freedom, security, and justice, and that would defeat the purpose of mutual trust. However, coming back to our national grounds, we see that paragraph 2 of Article 41 states that notwithstanding paragraph 1, the grounds for refusal or of suspension of enforcement under the law of the member state addressed shall apply insofar as they're not incompatible with the grounds referred to in Article 45. So this statement in paragraph 2 would appear to actually discredit what I just said with respect to Article 45, paragraph 1, and the exclusivity of these grounds for refusal. However, on the one hand, already, Recital 30 reminds us again of this by stating that a party challenging the enforcement of a judgment given in another member state should, to the extent possible and in accordance with the legal system of the member state addressed, be able to invoke in the same procedure, in addition to the grounds for refusal provided for in this regulation, the grounds for refusal available under national law and within the time limits laid down in that law. This is actually a very helpful statement, not provision, because this is not authoritative, as concerns time limits, which very often, with respect to enforcement proceedings, play a significant role. Now, the question may arise, and I would be grateful actually if later in the Q&A session you wish to actually share your experiences in this respect. The question arises as to what do we actually mean when we say that Article 45 regulates the private international law dimension of enforcement, but that leaves the possibility of actually, regardless of the exclusivity of the grounds under Article 45, that still leaves room to the national grounds. Which could be the examples? Well, among the grounds that afford the right to resist enforcement are, for instance, prior voluntary payment of the credit, immunity protecting specific goods on account of their professional destination, dispute over the ownership of the attached asset, and finally, violation by the enforcement officer of the procedural rules the officer was bound to follow to attach a particular asset. These are all grounds that you could use to prevent or to object to enforcement of a national decision within your member state. And these grounds also, as a result of the principle of equal treatment, are made available also to the judgment debtor that is objecting to the recognition and enforcement of a judgment which was rendered in another member state. Moving on to the grounds, the actual grounds for refusal of recognition and enforcement. Probably the two most renowned grounds are the ones found at subparagraph A and B. Subparagraph A states that the court addressed shall refuse recognition and enforcement of the judgment rendered in another member state if such recognition is manifestly contrary to public policy in the member state addressed. This is a very common and well-known ground for refusal of recognition and enforcement. It is meant to protect the fundamental values and core principles of the legal system of the member state addressed. These values must be so core to the legal system of the member state addressed that such legal system may not allow them to be breached within its own system. So a simple difference in legislation does not amount to a conflict of public policy. I should point out that the exclusion of public policy as a ground for refusal of recognition and enforcement was the object of major discussions during the recast process of the Brussels I regulation. And it was actually much commended by the Commission that was supporting deleting this ground, but member states were not willing to do it and did not agree to do it. I should point out that in some circumstances, the regulations that I mentioned earlier, the so-called second generation regulations, do provide for the exclusion of public policy or a different understanding. So this is already interesting. Now, personally, I find it that it doesn't come as a surprise that member states were not willing to relinquish public policy, because it is really meant to protect and ensure the stability of the core values of the member state addressed. When we talk about public policy, we talk about substantive public policy, but to some extent, and this has been the object of a great debate, we talk also about procedural public policy. Now, one of the reasons why the Commission supported the idea of deleting public policy as a ground for refusal of recognition and enforcement was the idea that actually the legal systems of the member states do not differ so much as to justify public policy. And this seems to be to some extent supported by the idea that actually there are not many cases where a court of a member state addressed refuses recognition and enforcement of a judgment rendered by the court of another member state on the grounds of public policy. However, and we will see it more in detail in the segment about the loss of mutual trust and the judiciary crisis in Poland, this is not necessarily always the case. And what you may find, this is a sweeping statement, but one of the core values that still triggers refusal for recognition and enforcement on the grounds of substantive public policy is freedom of speech and of expression. So in that regard, there is still a difference in the understanding of the member states of this area of the law, and the sensitivities differ to the point that actually quite recently, in July 2018, the German Supreme Court refused recognition and enforcement of a judgment rendered by the Court of Appeal of Krakow precisely on public policy grounds for concerns related to the freedom of expression of the defendant. We will discuss it more in detail later, but this is to say that on the one hand, it's true, substantive public policy does not really occur that often. However, it still may come into play, and this would perhaps support the idea that this safeguard should still be there. I mentioned briefly that public policy can be substantive, but it has been an object of long debate whether public policy can also be procedural. I shall point out that, of course, the court addressed may not review the judgment on the merits. It has to rely on the statements of law and facts made by the court of origin. This is also the value, of course, of the certificate under Article 53. What the court addressed also cannot do, it cannot review jurisdiction because, of course, and we know it, the whole structure of the Brussels I Convention and then Brussels I Regulation and Brussels I Regulation is premised on the combination of jurisdiction and recognition and enforcement, and the fact that one court will trust that the court of origin has properly established jurisdiction over the case that it decided. So, of course, the court addressed may not review the judgment for which recognition and enforcement is sought on the grounds of jurisdiction. But what the court addressed also cannot do is try to bypass this prohibition via public policy. And this is made clear under Article 45, paragraph 3, when it is stated that the jurisdiction of the court of origin may not be reviewed, and the test of public policy referred to in point A of paragraph 1 may not be applied to the rules relating to jurisdiction. This is just to make clear that the court address may not bypass the prohibition to review jurisdiction via public policy. And procedural public policy in particular. So the question arises as to what is left for procedural public policy. And for a long time, the debate actually seemed to point to an answer which amounts to not much, until practice actually proved this assumption wrong. And we have seen it in particular with decisions rendered by the Court of Justice of the European Union in this respect. Taking one step backward, One of the reasons why some commentators seem to point to the conclusion that there is no real room for procedural public policy under subparagraph A of this provision was that actually subparagraph B already takes care of the case of a default judgment rendered in a situation where the defendant was not placed in a position to defend himself or herself in a timely and proper manner. This is the provision laid out in paragraph B, and this is the provision that is meant to foster and protect fair trial in accordance with Article 47 of the Charter of the on the freedoms of the European Union, and of course Article 6.1 of the European Convention on Human Rights. So it was a little bit a common understanding that whatever is construed as public policy, procedural public policy, is already covered by subparagraph B. Until a practical case, a case in practice, proved that this is not always the case. And this, I'm just referring to Cronbach as a case of reference. However, of course, you know that there are also other cases in Inter alia Gambazzi. In Cronbach, in particular, the defendant in a criminal case, which also involved civil claims for compensation of damages, refused to appear in person, regardless of having been properly notified, and notified not only in a proper manner, but also in a timely manner, and was consequently construed as in contempt of court, and was therefore refused legal representation by the National Court. The court also, and of course, this was referred to the Court of Justice of the European Union to establish whether this is in compliance actually with Article 45 of the Brussels I regulation. And actually the court took a very strong position against this kind of demeanor, saying that the right to be effectively defended constitutes a fundamental right, and nothing can preclude the requested court to consider the refusal to hear the defense of an accused person who is not present at the hearing as a manifest breach of a fundamental right. So in this case, and also in the following cases that address similar situations, we see how there is actually room for procedural public policy beyond that covered by subparagraph B. So at present, more or less, and again in a sweeping statement, the situation is construed as follows. Whatever actually falls in the scope of subparagraph B is to be governed by subparagraph B. And anything that relates to fair trial and the right to defense that may not be traced back to subparagraph B may fall under subparagraph A, and therefore procedural public policy. Now, which means that subparagraph B more or less operates as lex specialis, and subparagraph A operates as lex generalis to some extent. Now, subparagraph B also actually undergoes to a minor exception or restriction, which is found in its last sentence, which states that, of course, the defendant may raise before the court addressed the issue that he or she was not properly summoned. However, this may be the case unless the defendant failed to commence proceedings to challenge the judgment when it was possible for him to do so. The idea is that this is to avoid any kind of abusive behavior on behalf of the defendant and, of course, of the judgment debtor. This is to avoid that the judgment debtor avoids raising issues of proper service before the court of origin and just waits until enforcement is sought in another member state. The idea is that all litigation, to the extent possible, must be dealt with the court in the member state of origin. And the rationale of this provision is exactly that one. Because of course, on the one hand, you want to avoid the abusive behavior that of a defendant that just waits until the last moment to raise its objections. On the other hand, it is assumed that the courts of the member state of origin are better placed to deal with this situation. Moving on to other two grounds for recognition and grounds for refusal of recognition and enforcement. These are found at subparagraph C and D, and they deal with irreconcilability of the judgment for which recognition and enforcement is being sought. Irreconcilability in the member state addressed vis-a-vis, on the one hand, a judgment rendered by the courts of the member state addressed, and this is found in subparagraph C, or a judgment rendered by another member state, by the courts of another member state, or the courts of a third state. These two provisions are similar, but they're not the same. As you may see, the threshold for refusal to kick in is definitely lower with respect to subparagraph C compared to subparagraph D, because in case of irreconcilability of the judgment for which recognition and enforcement is sought with a judgment rendered by a court of the member state addressed, it is sufficient that the judgment be given between the same parties. It is not necessary that it also relates to the same cause of action, unlike what put forth at subparagraph D. And also, it's not necessary that the judgment be earlier, whereas under subparagraph D, it is. And the idea is that the coherence of the legal system of the member state addressed is more at stake in case of irreconcilability of a judgment rendered by another member state with one of its own judgments. So the fact that its own judgment is rendered maybe even after the judgment for which recognition and enforcement is being sought is of no real concern, because the concern here is to ensure and foster the consistency and the coherence of the legal system of the member state addressed. And finally, an aspect which is a novelty in the Brussels 1A regulation. However, and it is the issue of adaptation of a judgment, which is governed at Article 54. This is a novelty in respect to the fact that now we have a provision which establishes and regulates adaptation, assimilation of a foreign judgment, whereas under the Brussels 1 regulation, this was not the case. However, it should also be mentioned that in accordance with the rulings of the Court of Justice of the European Union, and among the others, the ruling in DHL Express France, the Court of Justice had indicated that actually adaptation is a mechanism which is found in the general principles of procedural law in the member states, and that also as a result, of course, of mutual trust, the court of the member state addressed should always try and adapt an unknown measure or order within its own legal system. What this provision does now is clarify the terms of adaptation to the extent possible. Of course, some loopholes are still there, but at least it provides a solid ground. And it states that if a judgment contains a measure or an order which is not known in the law of the member state addressed, the measure or order shall, to the extent possible, be adapted to a measure or an order known in the law of the member state addressed. And this measure, the measure that will be used to adapt or assimilate the unknown measure, must have equivalent effects attached to it and pursue similar aims and interests. However, again, for the principle of equal treatment, for the logic of mutual trust and not having different judgments with different effects circulating in the area of freedom, security, and justice, such adaptation shall not result in effects going beyond those provided for in the law of the member state addressed. Indeed, a party may always challenge the adaptation. What you see here is that the idea is that the court is obliged to look into the possibility of adapting an unknown measure. What the provision does, it mandates the court to look into the possibility. However, of course, that doesn't mean that the court must adapt, because if it finds that there is no reasonable possibility to pursue that goal, it will not. But what is important is that at least now the court has some ground rules to actually adapt a foreign measure. What are examples of potentially unknown orders and measures? And again, I refer to you because certainly you have way more experience than I do. But some of them can be, for instance, a restraining order, a payment order or search order, penalties resulting from the infringement of an order, like the French astreinte, and freezing orders. Just to give you a quick example from practice, in a case where recognition and enforcement of an English judgment containing a freezing order was being sought in the Netherlands, the Dutch court acknowledged that its own legal system, the Dutch legal system, doesn't know the freezing order as understood under English law. So what the Dutch court did was assess the aim of such freezing order, and it stated that such freezing order is meant to restrain a party from disposing and dealing with his or her assets. And then it provided to try and identify an equivalent measure and order which is regulated and found under Dutch law. It did, and it found it in the so-called leave for attachment order. Now, Dutch commentators have objected that actually the Dutch measure is more far-reaching than the English freezing order. And while it is also being counter-argued that yes, this may be the case, however, there's always a possibility for the court of the member state addressed to try and tweak and twist, for lack of better words, the national measure order. And for instance, to try and counterbalance the fact that its own measure is more far-reaching than the original one by, for instance, requesting that the judgment creditor deposit a security. So this is just an example, and well, I thank you for your attention. And in the PowerPoints, you will find also a list of selected readings. I tried to be varied as to the origin of the authors, so I hope it helps. Thank you.